Adjournment request, if any, from item number 1 to 35.
Please, Your Lordship. With the concern of all the sides, I beg to make a mention for item number 4 to 35, Your Lordship. The senior counsel is out of station.
What remains then in the list?
Your Lordship.
What remains in the list now?
If a date
When?
first week of November,
When do you want?
5th of November.
But I appear in item number 4. This pertains to the state of Arunachal. At the first and second week of November, I have a little bit of difficulty. Can it be in the third week?
19th, Your Lordship.
Now let us fix the date.
19th.
Mm-hmm.
7th of November.
7th, my lord, I have a little bit of difficulty. Can it be in the next week, my lord, week after that?
All other cases are there, similar cases are there.
I understand. my lord.
They decided it's okay, that will cover your case. 2015, 16 matters.
I understand.
Doesn't look nice.
Just the next Tuesday, ma'am, if it is not inconvenient.
12th,
12th,
of November.
all right.
Right, but the request of the guard party to list these matters on 12th of November. Yes,
May I please, Your Lordship, kindly adjourn this matter, and for item 3, kindly adjourn for this matter for some 3 weeks time as my
why
senior,
3 weeks, madam?
is in bereavement of a family.
Three weeks.
It be covered. Yeah, I can remember 3 years ago.
From item number 36 to 47.
Your Lordship. With the consent of others, I beg to mention item number 36 and 37, Lordship. Secondly, has done for 3 weeks, Lordship. Machinery is out of the station.
Yes,
Please, Lord. My lord, I beg to mention item number 43, my lord. In this case, my lord, I have filed a reply affidavit which is not in the record, my lord, so it may be adjourned for the day and the matter may be.
you are for the,
Respondent.
you are for the.
I'm for the respondent number 1, my lord.
So they have already assessed.
My lord, they are not present in court, my lord, they also. Yes.
You are for the,
I'm for the appellant.
appellant state.
Yes.
Last, on the last date, we directed the metro, this DC metro to assess the compensation amount.
Yes, we have done it.
You have done it.
Already done it, my lord, and on that assessment, I have filed a counter reply regarding that some, as per my concern,
How much money you propose to give?
24 lakhs.
You bata. More you need. The matter is pending since so many years. Be
Yes, sir.
satisfied with the amount. Pass over for the day.
It may be 7th of November, my lord.
Pass over for the day. Next
Obliged.
Thursday को बन जाएगा.
Obliged.
May I please your lordship? Lordship, I beg to, with the consent of the appellant, I beg to mention item number 42, lordship.
42.
To engage legal aid counsel, Mr. A. Bhattacharya is out of station, lordship. For the sole respondent.
1B.
Much obliged.
Please, Lordship, Lordship, beg to mention item 45, Lordship.
Yeah.
Under acting counsel, Mr. Priya has been hospitalized, Lordship. Is medically indisposed, so it can be adjourned, Lordship.
2 weeks.
May I please, Lordship?
Okay, Lordship.
I beg to mention item number 47, Lordship.
Adjourn.
Lordship. Much obliged, Lordship.
Lordship, I beg to appear in 47, your Lordship.
Yeah.
Lordship, may I request for a specific date? They had informed me in advance, so I didn't come today, your Lordship. May I request
Date
Lordship, 12th? Could it be 12th of November, your Lordship?
12th of November. 12th of November.
Really obliged.
May I please your lordship? I am appearing on behalf of Mr. P. Mohanta for item number 38 and 39. With the consent of both the parties, I kindly seek for an adjournment, lordship, for the day.
After a week.
I pay for listing of this matter, my lord, detail on my lord 24. Similar matters are coming
Now,
up.
matters which are listed, please argue those matters.
No, my lord,
Listing
similar
of
matters are
case,
coming
listing
up on
of the case,
24.
the matters which are listed, you are not arguing those cases and asking for listing of other cases.
No, my lord, similar matters are coming up on 24. Lordship has directed us to provide a list that I have provided. These were both left out, my lord.
Granted.
Obliged.
Lordship, I'm praying for listing of 2 matters next week, your Lordship. They're in the hearing list, your Lordship. There's some development in the matter, hearing list, your Lordship. I'm praying for the listing of the matter any date next week, your Lordship.
Who is for the other side?
Other side, Lordship, Education Department approval.
We'll list the matters and then the other side will come and seek adjournment.
There's been development in the matter, your Lordship. They
Hearing
should.
the-
Any other request?
May I please your lordship? I beg to mention item number 48. As per instruction of our client, my lord, I will be allowed to withdraw this petition.
Then concept of the
Lordship.
petition, appellant on instruction is submitted that the, as great for withdrawal of the writ petition. Dismissed as withdrawn.
Obliged, Lordship.
Obliged.
My lord, I beg to mention for a listing, my lord, on next Friday, my lord.
Obliged.
Daily list for admission, item 1.
May it please, your Lordship.
Why don't you file a review petition?
My lord,
Why don't you file a review petition against the order of 3/1/2024? If the review decided against you, we can very well entertain appeal.
no, my lord, question is the learned single judge took the view, I should file either appeal or review. That's why we prefer this appeal, my lord.
No.
Kindly see, my
Nothing
lord,
single judge has observed that
kindly see, my
review-
lord, against,
Review petition has not been filed. We understand that. There's nothing. File a review petition if the single judge, or if there is no interferences, then.
no, my lord, Lordship will kindly consider me for a moment, my lord. Here is a case, the complainant
Yeah,
never
what-
alleged anything.
We have gone through the
Yes.
case on account of the against this clinic or the hospital or whatever it may be, and the doctor who has treated her. And direction by the Human Rights Commission is also against the doctor only
Others, yes.
and nothing else.
So, my lord, most importantly, nobody has taken this name. Where from the learned single judge got this name, my lord? Nobody is pleading this, it has come out. Lord, with all respect, I'll submit, my lord. It will be an abuse of the process of law. With all the sense of, sincerity, I'm making this submission, my lord. Nobody has uttered this name. Where from this name emanates? And my lord, is it the scope of Order 1, Rule 10, my lord? It's, with all respect, my lord, Lordship will examine this matter, my lord. And otherwise, the matter is fixed tomorrow before the learned single judge.
For what?
Otherwise, the writ petition will come up, my lord. And in fact, there is a direction that I should file an affidavit. My lord, I am no longer in charge of this management also in 2017 onwards, my lord.
Then when this incident took place, at that time.
No, the learned single judge's view was, my lord, either we should file an appeal or we should file a review. So we have preferred the appeal.
Against the, you have preferred the.
No, against the order of impleadment. If a lordship would kindly come,
2024 is not under challenge, sir.
my lord.
2024 is not under challenge against this.
Lordship will kindly bear with me, my lord. If Kumar Nursing Home is made a party, I have got nothing to say, my lord. Why me, my lord? Why as a doctor?
No, but this technically speaking, this 3/1/2024.
Yes,
The order whereby the learned single judge is directed to implead Dr. Jadhav Kumar
yes,
as party respondent number 8.
yes.
This order is not under challenge in this appeal. This is not under challenge.
No, my lord, as a proprietor, my lord.
No, what we are saying, sir,
If a lordship would kindly come to page 48,
page 49,
yeah, 49.
3/1/2024.
Accordingly, court impledes Dr. Jadhav Kumar, proprietor of Kumar Nursing Home. Where on this, my lord?
As respondent number 8. that is
Yes.
right. You are aggrieved by this order. Essentially, you are aggrieved by this order.
If a lordship would kindly come to the earlier paragraph, my lord.
Yeah.
This court, after hearing learned counsel for the parties, is of the opinion that Kumar Nursing Home, wherein the patient led was admitted as an operation, was conducted by him, is a necessary. To that extent, we have no problem, my lord. Let Kumar Nursing Home be made a party. But why, my lord, this proprietor, Mr. Dr. Jadhav Kumar?
Understand that.
I'm not the proprietor, my lord.
What we are saying, that this 3/1/2024 essentially is not under challenge in this appeal.
But this is not under appeal for the simple reason, my lord. To the extent of making Kumar Nursing Home a party, I have got nothing to say. But as a proprietor, I have been roped in, my lord. I'm no longer the proprietor. Everything was handed over in 2017. Let Kumar Nursing Home be implemented, my lord. That is not our objection. This second para, we have no problem, my lord. Technically, I already 779. Technical nothing to have. To the extent of third para petition. There are certain technical difficulties, my lord. First of all, my name is also wrongly, if the Dusty service was affected at home, my name is not the correct one. I do not represent Kumar Nursing Home. So in what capacity do I come, my lord? Otherwise, my correct name is Milord Jadhav Chandra Kumar. But when the Dusty service was affected, it was affected in this name. I cannot represent Kumar Nursing Home.
Then why you have filed this application as Jadhav Chandra Kumar, proprietor Kumar Nursing?
No, I have not.
No, I have not, Milord.
Yes, it is there.
Mistake.
In IA, this title
No,
is there.
that is a mistake in your, but in our application, how can I've not done, Milord. Our application is there. Page 56, Milord.
56.
Yes. Jadhav Chandra Kumar, son of late Hari Kumar, resident of so and so. In the order, my lord, it has been wrongly reflected. Page 56.
The amended quasi title which he has filed,
Page, page. Page, page. Page 77, my lord. Ito na. Serial 8, my lord. Dr. Jadab Kumar Das, proprietor Kumar Nursing Home. Somebody else. And 221, my lord, the dusty service that was effected. Para 2, that on 9/1/24, I had personally visited the residence of the newly implemented respondent number 8 in order to serve him a copy of the writ petition together with the order and tried communicating him about the next date of proceeding, which is scheduled to be listed on 12th of February. Said respondent personally received the copy of the writ petition.
and concept of the appellant has submitted that in the writ petition filed on behalf of the respondent, non-applicant, respondent. Respondent number 8 has not, respondent number 8, the appellant was not the party respondent because the respondent number 8 has not paid any relief against him. It is further submitted that none of the party has ever requested before the learned single just to implead the appellant as party respondent. Despite that, after observing that the Kumar Nursing Home, Kumar Para, is a necessary party in the writ petition, the learned single judge has ordered for impleading the appellant as respondent number 8 instead of proprietor of the Kumar Nursing Home. Learned Council has submitted that since 2017, the appellant is no longer a proprietor of Kumar Nursing Home. And in such circumstances, the direction given by the learned single judge to implead the appellant as respondent number 8 was unwarranted. Stop. Learned Council has further submitted that the learned single judge has dismissed the interlocutory application filed on behalf of the appellant solely on the ground that while observing that the same is not maintainable because the appellant has not sought review of the order dated 3/1/2024, whereby he was impleaded as party respondent. The Learned Council has submitted that even though if no review application is filed, seeking review of the order dated 3/1/2024 passed in writ petition number 7815/2015. The application referred by the appellant for striking of his name, his name from the array of the respondent is very much maintainable. Notice. You are appearing for?
Lordship, I am appearing for respondent numbers 1, 2, 3, and 5. Lord.
Mr. So and so put an appearance on behalf of the respondent number 1, 2, 3, and 5. Let notices be issued to the other respondents. In the meantime, the effect and operation of the order dated 3/1/2024 passed in writ petition number 7815/2015 to the extent of issuing direction to increase Dr. Jadhav Kumar as respondent number 8 shall remain state. Develop.
Item 2.
I am appearing for the caveat or original writ petition. Last time, my lord, it was agreed between the parties and that the matter will be disposed of. That's why it has come as, my lord, for disposal.
Last time?
As per your lordship's last order, the last order.
Yes, yes.
So many times it was adjourned. Lordship thought it's proper that it should be.
Matter will be heard at final.
Yes, yes. I'm prepared. my lord. No, my lord, we are assailing the order of the learned single judge. Lord, the learned single judge placed reliance on the judgment of the Supreme Court, where the facts are distinguishable, my lord. Where there was, my lord, that power to levy demurrage was not there. Here it is there. Now, if your lordship would kindly permit me to place
the agreement itself.
Yes, yes. If your lordship would kindly come to page 157.
157.
Yes, I'm straightway taking your lordships to that clause.
Yes.
Roman 10, my lord, towards the bottom.
Roman
10, my lord.
Yes.
At page towards the bottom.
Liability.
Liability of contractor for losses, etc., suffered by the corporation. The contractor shall be liable for all costs, damages, demurrages, wharfage, forfeiture of wagon registration fee, charges and expenses suffered or incurred by the corporation due to contractor's negligence and unworkmanlike performance of any services under this contract, or breach of any terms thereof, or his failure to carry out the work with a view to avoid interference of incurrence of demurrage, etc., under the contract, or breach of any terms and conditions, or has a failure to carry out the work with a view to avoid the incurrence of damages, etc., all over the etc. I'm sorry, Milord, I'm handing over to legible copies.
You get your
yes.
Number changed. Yes.
I'm kindly handing over.
Yeah, please.
I'm reading it once again, Milord.
Yeah.
The contractor shall be liable for all costs, damages, demurrages, wharfage, forfeiture of wagon registration fee, charges and expenses suffered or incurred by the corporation due to contractor's negligence and unworkmanlike performance of any service under this contract, or breach of any terms thereof, or his failure to carry out work with a view to avoid incurrence of demurrage, etc., under this contract, or breach of any terms thereof, or his failure to carry out the work with a view to avoid incurrence of demurrage, etc., and for all damages or losses occasioned to the corporation due to any act, whether negligent or otherwise, of the contractor themselves or his employees. The decision of the general manager regarding such failure of the contractor and their liability for the losses, etc., suffered by the corporation and quantification of such losses shall be final and binding on the contractor. So we are concerned with, my lord, demurrage. Now, my lord, if a lordship should kindly come to now, so this is the enabling provision. Now, lordship should kindly come to page number 186. These were the notices, my lord, which were issued by the FCI authority to the contractor. On 15th of March 22. Non-lifting of food grain indent for FSD Badarpur Ghat regarding. It is intimated that a rice rake bearing so-and-so was placed on 14/3/22 at 2:30 hours at RS Salsapara, in which indent of 10 wagon was made for FSD Badarpur Ghat with a precaution that panel DC demurrage charges being imposed at SCA, you are requested to make
Panel DC
demurrage charge, my lord. Demurrage charge.
demurrage charge.
Demurrage charge. Being imposed at the SCA, you were requested to make necessary arrangement for positioning of adequate men and machinery for early release of the wreck. Till this hour, that is so-and-so of 15/3/22, 4 wagons assigned for FSD Badarpur Ghat are still pending for unloading. The matter has also been apprised to you through telephone. However, no further communication is received from your end, nor the representative of the high-speed logistic is available at the site. This clearly shows major lapses from your end. So this is one notice. Then my lord will kindly come to the next page, 187. This is another notice. It has come to the notice that labor strike has become a regular practice at FSD Badarpur Ghat. On this date, it is intimated by the MD so-and-so that trucks are stranded for want of unloading as of 15/22 hours and no work is started. Similar instance was also happened on 14/6/22 and no receipt issue operation could be carried out. As you are aware that due to disruption in rail movement, food grains are being inducted by road X so-and-so at higher cost in order to meet NFSA requirement of the valley and maintenance of sufficient buffer stock of the valley. It is regretted that in spite of being aware of the emergent situation in the valley and challenges being faced by the corporation to maintain food grain chain smoothly, regular occurrence of strike by labor at FSD Badarpur Ghat has posed the challenge in maintaining sufficient quantity of food grain. If the same situation persists, then it will be difficult even to run PDS chain and maintain buffer stock to meet any unforeseen situation. Your lackadaisical approach has put FCI in a deep trouble in respect of supplying food grains under various government schemes and also maintaining buffer stock in the valley. It is therefore directed to withdraw the labor strike immediately at FSD Badarpur Ghat, failing which necessary action penalty as per so-and-so will be imposed. Then, my lord, I'll refer to another notice at page, next page, my lord, 188, on the similar lines, my lord. Yes. Now, my lord, I'll place before lordship the chart which will depict the correct picture about the whole situation. If your lordship would kindly come to page 108. Now, as far as the contractors are concerned, my lord, on the right-hand side are the name of the contractors and the place from where, my lord, this roads are, the rakes were to be unloaded. Badarpur High Speed, I think third from the right-hand side, my lord.
108.
Yes, 108, page 108.
Badarpur High Speed, yeah.
Yes. Now, I'll just give an example, my lord. For example, It took in last one. Source. Acha. Now, my lord will kindly see date of placement. There is a column. 1, 2, 3, 4. Fourth column, date of placement.
Yeah.
And next column is date of completion. That will show, my lord, whether the rakes were unloaded within time. For example, my lord, on the top, 2/12/21, the date of placement and the date of completion was 3/12/21.
Fine.
Therefore, my lord will kindly see. And kindly see, my lord, next column, demurrage hours for entire rake, 308.45. Demurrage occurred so and so. Now, if your lordships will kindly come to the high-speed column, since there was no delay on the part of the respondent petitioner, my lord, so no demurrage charge was levied.
The respondent petitioner,
High speed, 0.
Badarpur high speed.
Yes, 0. So for that, my lord, transaction, since there was no latches on the part of the respondent petitioner,
It is in relation to petitioner only.
no, so many contractors, my lord.
MKS. The first column is in respect
No,
of.
no, my lord, MKS is the source from where it has come.
So it relates to this petitioner only. ये कहाँ से देखेंगे? sir?
Yes.
From where we'll get?
मतलब respondents are this, my lord. N Bazaar, Anup আছে, handling SCA, Anup, then RBEE, Anup, high speed, B Roy. এটু কি নাম MKS তো? ওপরে আইছে। কিন্তু FSD বলো তাৰপিছত নাম কিটা হল কন্ট্রাক্টর Milord, just to clarify, Milord.
Yes.
Source means the station from which the food grains are lifted.
Fine.
And Milord, on top, Lordship finds the name and N Bazaar, that is the food storage depot.
Fine.
Then Ramnagar is the Milord, another one. Badarpur is another one. And the high speed is the respondent petitioner, the contractor.
Fine.
Now, Lordship, from this chart, Lordships will find, so wherever there was no latches, no demurrage charge was levied. Wherever there was, my lord, delay in unloading, then demurrage charges
No,
were.
they are not disputing this. Whatever the charges, they are simply disputing that there is no provision in the contract.
Yes.
And that's why they
Yes.
can't.
And I have to satisfy Lordships only on that point. That there is a provision.
Yes, Mr. Badra, this
Yes.
is what your case is. That since you are not disputing the demurrage charges. You are simply disputing that since there is no provision in the contract itself, and so can't be imposed.
That is one.
And the net single judge has decided your writ petition only on this premise.
Yes.
That is one. And assuming there is a power given in the contract, the question is not the power itself to levy. Question is how you have exercised your power.
Oh, that's
That is another aspect.
That's another aspect we'll hear you.
Yes.
Are you not supposed to go through a process of inquiry and then
Yeah,
give a
that's
notice?
right. That's another.
Both fronts.
First of all, we are simply trying to understand this issue, whether there is any provision or the Supreme Court judgment is applicable in the facts of the case or not. That is what we are.
And my lord, page 109, we have given a chart wherefrom it will appear in what manner, my lord, the levy was imposed. But he is a transport contractor. A গাড়ী প্লেচ কৰিব আৰু সি বস্তু আনিব হেণ্ডলিংও ট্ৰান্সপৰ্টাৰ মানে গাড়ীও প্ৰভাইড কৰিব লেবাৰো প্ৰভাইড কৰিব Now, if your lordship should kindly come to page 109 for a moment, sir. I'm sorry. No, no, Bhadrapur hato to moi to beleg udhaharon kiya di. Bhadrapur hato. সেটা তো ডিল করেছে 266 more contract to pay, more contract to pay. Contract to upload, place আমি ছাড় আনলোডিং করার কারণে আমরা কথা বলি লেবার পাচ্ছি কি মনে না না আমার এলিগেশন রিপ্লেস দিতে আমার কোড করতে men and machinery will go. Labor strike people কথা মনে নেই what is the scope of the problem
Therefore, directly to supply requisite number of trucks immediately to deliver in that state.
he was there in the police of the place not one there will be supplier is 257 no?
Yes.
Yes. If your lordship would kindly come to page 188 for a moment, my lord. My lord, his duty was to place trucks. Unloading was not his role. Yes. Page 188.
Yes.
Last notice, last para. Your lackadaisical approach has put FCI in deep trouble in respect of supplying food grains under various governmental schemes and also maintaining buffer stock in the district. It is therefore directed to supply requisite number of trucks immediately to release the stranded wreck, etc., so as to avoid further detention of wrecks, failing which necessary action penalty, etc. shall be imposed. Now, my lord, the petitioner respondent does not dispute their position. If your lordship will kindly come to page 214, their affidavit. Page 214.
Yes.
Somewhere in the middle, my lord, slightly below the sentence starting with, it was further stated. Page 214.
Yes. That due to statutory
Yes,
RTO.
it was further stated that although due to statutory RTO document problem of the truck supplied by Salsapada Truck Owners Association, there was delay in supply of trucks. However, the deponent was in constant contact and continuously requesting association for resolving of the issue so that immediate supply of trucks could be resumed. Despite having been assured by the association for early solution, deponent made alternative arrangement for so and so, so and so. So, my lord, he virtually admits, my lord, what arrangement he had with the Lord, that association, that is not our lookout. As far as we are concerned, we know you as a contractor. So your duty was to place adequate number of trucks so that the food grains can be unloaded. So that he failed. Now, my lord will now kindly come to the Supreme Court judgment. I'll demonstrate, my lord, how the facts are totally different. The judgment of the Honorable Supreme Court is at page 237, my lord.
Yes.
But I'll have your lordship's kind attention to page 246.
Yes.
Page 246,
Yes.
para 16. The core question arising for our consideration is whether contractual clause enabling corporation to recover charges includes recovery of damage. It is pertinent to extract the relevant clauses of the road transport contract, that is work order, the clause detailing the description of the work, liability of the contractor and power to recover losses which are identical in the three appeals before us. Now please come to my lord the Roman 10A. Liability of the contractor for losses suffered by the corporation. The contractor shall be liable for all costs, damages, registration fee, charges, expenses suffered or incurred by the corporation due to contractor's negligence and unworkmanlike performance of any service under this contract or breach of any terms of the contract or failure to carry out the work under the contract. So here lordships will find that word demurrage is not there. That is the reason. Unlike in the present case, my lord, at 157, where I have already read that demurrage part is there. Now, my lord will kindly come to next page, para 17.
Yes.
The corporation seeks to recover demurrages as a part of the charges provided under clause 12A as extracted herein above. The expression charges standalone is not amenable to a precise meaning. Its dictionary meaning is open textured, defining charges as any consideration that one must pay for the goods and services provided. Therefore, the scope of the expression charges must be understood as intended by the parties to the contract. The process of interpretation, though the exclusive domain of the court, inherits the duty to decipher the meaning attributed to contractual terms by the parties to the contract. It is with this purpose that we shall now proceed to understand the meaning of the expression charge. There are certain basic principles evolved by the court of law for deciphering the true and correct meaning of expression in a contract. In Bihar Electricity Board versus so-and-so, this court observed that every contract is to be considered with reference to its object and whole of its terms, and accordingly the whole context must be considered in endeavoring to collect the intention of the parties, even though the immediate object of inquiry is the meaning of an isolated cause. So, my lord, the Honorable Supreme Court decisions are cited. Then, my lord, may kindly come to page 250, para 22. Keeping in mind the above referred principle, I'm sorry, my lord.
Yeah.
Keeping in mind the above referred principle, we have to examine the expression charges in the context of its related words in the contract, which are costs, damages, registration fee, and expenses. These expressions indicate different heads under which losses are recoverable from the contractor for the acts of negligence, unworkmanlike performance of any service, breach of terms, failure to carry out work in the context of working of the contract. These expressions are equally wide, and to not aid us in understanding the meaning of the expression charges, under these circumstances, we have to understand the meaning of the expression charges in the larger context of the contract. Then, my lord, will kindly come to page 252, para 24. Now, this is very important, my lord. We have scanned the entire contract in addition to scrutinizing the provisions extracted above and seen that there is no contractual provision requiring contractors to undertake the task of loading and unloading of food grains from the railway wagon. This is confirmed by the written submission on behalf of the corporation, where imposition of demurrages is justified only for the reason that contractor did not provide adequate number of trucks near the railway siding to enable the corporation to promptly hand over food grains to them to commence the transportation. if I have correctly understood, my lord, what had happened in this case, more emphasis was laid on, my lord, loading and unloading part, though the duty was of, my lord, providing the vehicle or placing the vehicle. My lord, in this case, in the present case, we have not charged the demurrages from him as has been imposed by the railway for not, unloading the way from the wagons, the food grains. We have charged him only because he has failed to place adequate number of trucks whose presence would have enabled, my lord, lifting of the food grains. So this is the distinguishing feature, my lord. Then para 25. We may note that there is a dispute about availability.
Distinguish.
My lord,
The case of the respondent before or the this FCI before the Supreme Court is also this. This is confirmed by the written submission on behalf of where the imposition of damages is justified only for the reason that the contractor did not provide adequate number of trucks near the railway sidings.
yeah, no, my lord, if your lordship will kindly come to para 26, that will clarify everything. Para 26. Irrespective of the disputed fact, yes. তাকে আনলোডিং করার কেন চার্জ করেছিল আসলে Para 25, my lord.
Yes.
We may note there is a dispute about availability of truck for transportation of food grain by the contractor. While corporation asserts that trucks were not made available in the number as well as in time, contractor denies the same, stating that trucks were kept waiting at the corporation's food security. So this was the fact situation in the case before the Honorable Supreme Court. Irrespective of the disputed fact, the real question is whether contractors had any obligation towards loading and unloading of food grains from the railway wagons. It is evident from the contractual provision and also admission of the corporation in written submission that task of loading and unloading of the food grain from railway wagon was not a part of the contract. Thus, based on the interpretation of the expression charges in contextual context, we're of the opinion that it did not include liability on account of damages. Consequently, the corporation cannot impose and collect demurrage from the contractor. Now, this is not the situation here, Milan. In our present case, our specific case is they have failed to place the adequate number of vehicles as was mandated by
There was no dispute about loading and unloading.
Yes. This is the distinguishing feature, Milan. So this could not have been the sole basis of deciding, because Honorable Supreme Court was also of the view that there is an element of disputed question of fact. I'll read it again, Milord. Para 25. We may note there is a dispute about availability of trucks for transportation of food grain by contractor. While the corporation asserts trucks were not made available in the number as well as in time, contractor denies this claim, stating that trucks were kept waiting at the corporation's food security depot. Irrespective of the disputed fact, the real question is whether contractors had any obligation towards loading and unloading of food grain from the railway wagons. It is evident from the contractual provision and also admission of the corporation in the written submission that the task of the loading or unloading of food grain from railway wagon was not a part of the contract. So in fact, my lord, Food Corporation of India also admitted before the Supreme Court that their responsibility was not also included loading and unloading.
Here is the same case.
No, here is the same case, but we have imposed the demurrage charge only for not placing the vehicle. My lord, end of the day, a time slot is given. Within that time, my lord, if we do not place the contractor do not place the vehicle, then the railway will impose demurrage charge. Then we have to pass on to the contractor. That is the contractual stipulation. Our allegation is not that you failed to unload. That is not our case. Our case is, my lord, you failed to place the adequate number of vehicle in terms of the contractual clause. Then, my lord, please come to page 256. In fact, the last sentence at page 256. Yes. We have every reasons to believe that the court, I'm sorry, Miller.
Just a matter. This page 186.
Yes,
This
Miller.
notice,
186, Miller.
15/3/2020.
Yes.
This says it is intimated that the rice rack bearing number so and so was placed at Itaita Salchapura, in which the indent of 10 wagons were made by the FCA with precaution that panel DC being imposed at the SCA. You are requested to make necessary arrangement for positioning adequate men and machinery for early release of the rack.
Men and machinery means, my lord, the trucks and the drivers, handymans, all this stuff.
So this is then till at this hour on Itaita, 4 wagons assigned to FSD are still pending for unloading.
Yes.
So unloading was not his
No, my lord.
part.
No, my lord, unloading not on account of not unloading by the laborer. It is on account of non-placement of the vehicle. Subsequent line.
It is not clarified, sir, here.
No, no, my lord, the matter also been apprised to you through telephone.
Yeah.
However, no further communication received from an end, nor representative of this available site. This clearly shows. No, my lord, if your lordship will kindly come
Now next notice.
Yes.
Now come to next one.
page 187, my lord.
Yeah.
Yes.
This says it is regretted in spite of being aware of emergency situation, value changes faced by the corporation to maintain food grain chain smoothly. Regular occurrence of a strike by the labourers as FSD. Badarpur has also posed a challenge to maintain sufficient quantity if the same situation persists so and so. Directed to withdraw the labour strike immediately at FSD. How he is concerned with the labour strike, sir? He has to provide trucks only.
In the food storage godown, he was also the handling contractor. In respect of FSD Badarpur Hat, he was the handling contractor. He had 2 roles, my lord.
But you are saying na that you
No,
are
no,
not having.
no, Madam, the last notice 188 is very clear. Please come to
Yeah,
188.
188 is clear
Very
that you are not provided.
No, Madam, this
number of
notice
plans.
187, it was for the labor part because he's also handling contractor in respect of the Badarpur Hut.
But these damages were
Only for
levied only for
non-placement of vehicle.
not of this.
No, 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 not of 187. No. But 188 is very clear.
Yeah, 188 is clear.
Very clear. Now, my lord, before I read the judgment, my lord,
Yes,
if your lordship will come to the very first page of the Supreme Court judgment, my lord.
Yeah.
Para 2, last sentence. Page 237.
Yeah.
In one such contract, the subject matter of the present appeal, the corporation empowered itself under clause 12A to recover damages, losses, charges, cost and other expenses suffered due to contractors' negligence from the sum payable to them. Clause 12A has already been, I have already placed it at page 246, minute. The short question arising for consideration is whether demurrage charges imposed on the corporation by railway can in turn be recovered by the corporation from the contractors as charges recoverable under clause 12A of the contract. In other words, does contractors' liability for charges, if any, include demurrage? Because demurrage was not even expressly included, unlike in our case, my lord. Now, at 246, that clause 12A is quoted, my lord. The A, recovery of losses suffered by the corporation. Corporations shall be at liberty to reimburse themselves from any damage, losses, charges, costs, or expenses suffered or incurred by them, or any amount payable by the contractor as liquidated damages as provided in clause 10 above. So, what was an issue before the Honorable Supreme Court was, my lord, by virtue of clause 12A, read with clause 10A, whether demurrage charges could have been recovered from the contractor, handling contractor. Because clause 10A does not expressly provide the demurrage charges. That is why, my lord, in page number 256, page 256, para 30, last sentence. As the present contracts do not involve task of loading and unloading of food grain from the railway wagons as a part of the contractor's liability, there is no clause enabling recovery of damages from them by corporation. Thus, our interpretation of the expression charges as exclusive of liability for damages stands confirmed. So, the Honorable Supreme Court clearly, my lord, concluded that in the name of demurrage, you cannot burden the contractor with the liability which has been fastened by the railway, because the contract that is clause 10A, it does not include the expression demurrage. Now, if your lordship will now kindly come to the impugn order of the learned single judge, please come to, my lord, page 269.
Yes.
Para 14.
Yes.
Now, if your lordship would kindly come to page 266, para 8, where learned single judge, my lord, rightly appreciates the facts. From the above at page 266, it would be apparent that allegation of negligence on the part of the petitioner company in its failure to place trucks with the free time is a heavily disputed question of fact. So the factum that demurrage was imposed for non-placement of vehicle is also admitted by the learned single judge.
That is heavily disputed.
No, no, disputed, no, my lord. No, the context in which that sentence is made, because the stand was sought to be taken by my lord, other side, we also asserted a right. In that context, what would be the actual state of affair, that is disputed. But the factum that our emphasis was on non-placement of vehicle, that has been rightly appreciated by the learned single judge. Now, my lord will kindly come to page 269. Now that clause 10A is quoted, where on the very first line, the expression demurrage appears.
Yes.
Now please come to 270.
Yes.
It is no doubt correct that demurrage is included in clause 10A of the contract on top. However, since writ petitioner was not entrusted with the task of unloading the wagon ex railway siding Salsapara, in view of the decision of the Supreme Court, the said clause in the contract agreement, in the opinion of this court, cannot be interpreted as a provision in the contract permitting levy of demurrage upon the contractor. It may be the case that due to default on the part of the petitioner to place the truck at railway siding, there was delay in unloading of the railway wagon and on odd occasion as a result of which unloading could not be completed within the free time, thus inviting demurrage being imposed by the railway upon FCI. However, since the petitioner was not responsible for unloading the wagon, the FCI authorities cannot unilaterally deduct amount of demurrage from the bills of the contractor on such account. In other words, imposition of demurrage by FCI upon transport contractor cannot be based on mere ipsit of the general manager or any other official of the FCI coming within the definition of clause 1.5 of annexure 1 of the contract agreement. Such a claim against the transport contractor would be maintainable only when there is a proper determination of claim by following due process under the law, wherein the contractor is given sufficient opportunity to produce his version along with the evidence. Otherwise, FCI authorities cannot maintain a claim against the contractor for recovery of damages, save and except by obtaining a decree from civil court or any other adjudicatory order or award. But my first objection to this observation of the learned single judge was the learned single judge should not have entertained the writ petition if it involves a disputed question of fact. They could have been, the learned single judge should have referred them to either arbitration or to civil court. Now, having decided, you cannot take that plea. Am I clear to Lordship Miller? Now, here the learned single judge proceeds on the basis that based on the materials which was available, a conclusion could not have been arrived at whether there was any negligence on the part of the contractor. If that is the position, the best option for the learned single judge was to relegate the parties either to arbitration or to civil court. Now, my lord, kindly see, is it the case of the petitioner that we have imposed this demurrage charge for not handling the, consignment from the wagons? No. Our specific case is you have failed to place the adequate number of vehicles in terms of the contractual clause. Now, both ways, my lord, things cannot be taken note of. In view of the decision of the Supreme Court in Abhijit Paul, said clause in the contract cannot be interpreted. So, my lord, the Abhijit Paul's decision of the Honorable Supreme Court, which was rendered in the context of a different facts altogether, ought not to have been relied upon by the learned single judge. Had it been a case where the facts are similar, then it's a different issue, my lord. Here the facts are altogether different. It will make you believe, right? Last para. Now, if your lordships will kindly take note of page 274, last para of the impugned judgment, my lord. Page 274, last para. This order would, however, not preclude the respondent from initiating any action against the writ petitioner for realization of damages and compensation, if any, in accordance with law and in the light of the observations made herein above. On one hand, my lord, there is a finding by the learned single judge that there was negligence on the part of the petitioner contractor, which only can enable us to maintain a action for damages. And on the contrary, for the view that it involves disputed questions of fact, therefore we were not correct in taking at the stand which we have taken. It's contradictory in my humble submission, my lord. The first thing which the Honorable Supreme Court decided was, my lord, that whether for for unloading of materials, whether a transport contractor can be made liable. That was the issue before the Supreme Court. Issue before the Supreme Court is not that the comprehensive contract, it was a comprehensive composite contract of both handling and transport. In our case, my lord, we are concerned only with the transporter, my lord, placement of vehicle.
Yes.
So, my lord, on the whole, for a moment, if your lordship will kindly come to page 109 for a moment, my lord. Kindly see on the top, Indent versus supply and demurrage charge fixation. Heading. Now, kindly see, my lord, depot destination, we are concerned with Badalpur. Indent was for 10 number of wagons. Quantity in metric ton was 630. Quantity unloaded was 647. In fact, his performance was better, my lord. That's why kindly see, he has got minus 17 point so and so. So this will be adjusted where if there is any deficiency. Then if your lordship kindly see destination wise fixation 0, because he could within the free time he could place the vehicle. Then my lord will kindly come to the next date 4/12/21 on 26/11. Number of wagons 7, quantity 441, quantity unloaded, my lord 338. So there is a shortfall of 102. Therefore, 3270 was 3,200 and 700 was imposed. Sorry, 32,700 was imposed. Then similarly on my lord 6/12, Badalpur 10 wagon, quantity 630. He could do only 583. So there was a shortfall of 46. Accordingly, demurrage charges levied. So this is how it operates, my lord.
Yes.
And my lord, if your lordship would kindly come to page 108 for a moment. HTC money? And
Yes.
RTC money ki?
Road transport.
If your lordship would kindly come to page 108.
Yeah.
Right hand side is RTC, my lord, that is road transport contract. Before that, if your lordship will kindly see HTC, handling transport contractor.
Yeah.
See, my lord, nothing was imposed on him. That means he performed his part. So the chart itself bifurcates between handling job and transportation job. So we have not penalized him for handling part. So therefore, my lord, reliance of the Supreme Court judgment, in my humble submission is, my lord, was not proper.
Yes.
Incorrect. So my lord, to cut short the whole thing, my lord, he was essentially a transport contractor. His obligation under the contract was to place the vehicle within the free time. And my lord, the handling contractor will do the unloading job. And depending upon my lord, whosoever's liability is there, authority took the call. Now, it is not the case of the writ petitioner before the learned single judge that they have also been charged for the handling part. That is not their case.
That is not there.
Yes. So therefore, my lord, the learned single judge's view is apparently wrong. So there's nothing to be, I mean, there's nothing which could not be, my lord, deciphered. Everything was visible. So there is a clause which permits levy of demurrage charge, unlike in the Supreme Court, where it was not there. Therefore, the issue before the Honorable Supreme Court was the expression charges, whether it will comprehend within its, I mean, purport also demurrage charge. Supreme Court says no. So that Supreme Court judgment could not have come in handy in this case. End of the day, my lord, every contract has to be given its own independent meaning. The intendment of the parties entering into the contract was very clear. If you do not place the vehicle within time, then you carry the risk of, I mean, that liquidated damages in the form of demurrage. So that is my humble submission, my lord. With all respect, I'll submit. The learned single judge, my lord, ought not to have relied upon the Supreme Court judgment to arrive at the conclusion. First of all, my lord, that the facts are distinguishable. And secondly, it's not a case where, unlike before the Supreme Court, there is no power enabling the corporation to, I mean, appropriately, my lord, charge the demurrage charges. That's my humble submission. With the lordship's kind permission, my learned friend is deep level.
My lord, above the purported allegations of failure to place trucks in time, out of hundreds of consignments during the 2 years of contractual period, only a few notices were given by them. But there were hundreds of entries of demurrage cut. And I replied even to those few notices. One notice was like that, well, the entire railhead is occupied by cement bags and other articles. We are in the gateway. We are not allowed to enter into it. There is no place to enter. So these are the questions of facts. And in spite of saying that these are disputed questions of fact, both in Abhijit Pal's case, learned single judge and Supreme Court put that aside. The question basically is, how did they exercise their power, even if there is a power to cut? Basically, and learned single judge specifically dealt with that. Even the Supreme Court specifically dealt with that aspect also. Now, what we challenged is, my lord, your lordship will find, we have in our petitions, we have made certain specific allegations. There are free time hours. Wagons come from, say, from Gujarat with food grains of Punjab. New Guwahati is the rail yard. So mostly the wagons come during the night hours after 12. And the babus that the FCI officials are, they turn up next morning at 9 o'clock. We are not the consignee. Even the handling contractor is also not the consignee. Consignee is the FCI. The dabbas come under seal and lock. There has to be a representative from the FCI and there has to be a representative from the railway. That's why we make in our petition the railway a performer respondent. Now there are ledgers. The time has to be noted down in the ledger, which hour. That will have to be unsealed. So the handling contractor, even if he is there, he cannot open up and accept delivery of the goods. It is ground situation, ground realities. But sometimes the ground realities may not work, the documents work. But I'm stating because we made categorical statement in my writ petition. The type of order they pass, so therefore, my lord, 8 hours period, there is a slab, my lord. Station, arrival, till 4 hours after arrival, free time. If you fail to unload within the consignee, if you fail to unload it, then subsequent 1 hour, so and so rupees, subsequent 2 hours, 3 hours, goes on and adds on. That is what is my lord demurrage charge. So within 3 hours, many things are there. The type of my lord demurrage charge orders, I'll have to apprise your lordship by annexer page 72, my lord. FCA circular. Below 2.5, page 72, 2.5. Free time for loading and unloading of various types of block rakes in case of freight, terminals, sidings. Then right-hand side, free time, EOL, unloading 5 hours, 2 hours, 2 hours, depending on what the size of the truck, wagon is. Then next page 73, rates of demurrage charge. Demurrage charge be levied at the rate of 150 per 8-wheeled wagon per hour on part of an hour for detention of wagons in excess of permissible free time for loading and unloading. Then the rates demurrage charge prescribed above shall be applicable equally to all types of 8-wheeled wagons, coaching vehicles other than passenger vehicles, irrespective of the carrying capacity. Rates of demurrage charge in respect of 4-wheel shall be half of the rates prescribed for 8-wheeled. Then 3.4.2. The rates can be increased by say 2 times, 3 times or so on, and not necessarily 6 times at one go at all. In fact, railway may decide to levy variable rates like 2 times for first 3 hours, detention 3 times. So from their record, the railway straightway charges demurrages from the FCI on failure. Railway straightway, FCI becomes liable for demurrage to the railway. Fine. FCI is the consignee. Now, what do? They gives in then, we place trucks and they passes order like page 79. This is the order, unilateral orders. They simply pass on the buck on the contractor. Sanction order, they call it sanction order. Page 79.
79.
Page 79. Who issues it? It is the manager accounts. One such order, my lord. The manager, sanction is accorded for the payment of the following transportation bills in respect of road transport contract, high-speed logistics, private limited for transportation of food grain bags from the route X railhead, Salsapra to FSD, Badarpur Ghat. The manager account silver is requested to make payment after thoroughly checking verification of the bills and deduction of demurrage liability. Then kindly see the box. Income tax, all right, no question. TLOS SD, DC is the demurrage, 63,730 particular to one wagon, one consignment maybe. So this is unilaterally done. There is a procedure prescribed. That's where the visits case is the main contention. Whether the power is there or not is different thing.
The procedure prescribed that this for 1 hour, this would be the charges.
Yes, they don't apprise us. One, it has been, this is the order, and immediately on passing of the order, the amount is deducted. I came here, and therefore the learned single judge, by way of an interim order, prevented them from realizing demurrage, which also they didn't. In any case, now it is final hearing. So this is unilaterally issued. I am not allowed to confront. They are not saying from which hour to which hour the delay was there. How many trucks we placed or how many trucks we could not place. No speaking order, nothing. At one go, they give a sanction, they pass. This is the type of the order. This violates national justice. This violates Article 14. So, can I, my lord?
Yes,
So, my lord, 79, page 79, demurrage charge is certain amount. Why it is 63,000? Why it is not 74,000 or 29,000? What process you have followed? Am I not entitled to know it? They have followed no process, simply passes on the buck. Come to the previous page, page 78. There is a chart, and this was the position till the date I filed a writ petition before the Planet Single Investment.
this is what?
So these are the amounts, my lord. By that time, till the time of filing of the writ petition, my lord, it was 64 lakhs and odd. I finished the term till the date of my completion of the contract, my lord, which was otherwise blemishless. No notice of blemish was given or any other negligence. Till disposal by the learned single judge, my lord, the demurrage charge deducted by FCI came to more than 2 crores. 2 years contract. All in unilateral. Same notice. Same sort of notice, cyclostyle. Only the amount is different. Now, here I believe that a process is required is what the Ovijit Pulse case, my lord, the Tripura High Court, Learned Single Judge said, went on appellate court in Tripura, affirmed it, and then this Supreme Court judgment. So let me first place Ovijit's case, my lord. Let us see what were the factual statements. What is the original case? Ovijit, yeah. So this is the single judge judgment of Tripura High Court, affirmed by subsequently by the Tripura High Court Division Bench, and then by this judgment, Supreme Court, FCI's appeal was dismissed. Paragraph 7, my lord.
Yes.
So-and-so counsel appearing for the petitioner submitted that action of the respondents is entirely arbitrary and abuse of power in as much as petitioner didn't have any opportunity whatsoever either to deny or admit fully or partly the damage as determined by the Food Corporation. As there is no contextual liability such as determination is bound to be arbitrarily and colorable exercise of power. So-and-so learned senior counsel relied on a decision of Guwahati High Court in Bulbul Enterprise. I will show that, my lord. Where it has been held that the powers of the court under article is discretionary, it has to be invoked consideration of the facts and circumstances. Where the dispute centers around arbitrary and unfair action, the court shall not refuse to invoke such jurisdiction. Dispute is raised everywhere. A given chance, my lord, dispute is raised. To come to the question of alternative remedy. And Whirlpool said, if there is a violation, sheer violation of natural justice, the question of alternative remedy will not prevent from entertaining a writ petition by writ petition.
That's another.
That is settled principle. Proceeding further. In Bulbul, the Guwahati High Court has further held that the respondent shall act in strict compliance with the provisions of the terms and not to deduct any amount on account of demurrage without undergoing an exercise as provided under clause 12 of the contract. There cannot be any amount of doubt that respondents have failed to show that there had been any provision like clause 12 in the relevant agreement. As such, the petitioner cannot be saddled with any contextual liability in absence of such express provision, making good the loss that has purportedly been sustained in the respondents during the execution of the transportation. However, it is settled that even in absence of any agreement or contract, the petitioner may be held liable if it can be substantiated that for all negligence or dereliction of the petitioner, the respondents have suffered loss in their course of transportation, but for that purpose, there shall be an inquiry where the petitioner must have his say, or the respondents may take recourse to a procedure established by law for realizing the damages, if any. Then, my lord, having held so, respondents are directed either to determine damages following process of law, natural justice. Only in that event, petitioner can be asked to make good of the loss. In the result, respondents are directed to assess the loss, if any, they have suffered at the hand of the petitioner. After affording petitioner, the respondent shall refer some deducted from the transportation bill. Now, taking up this was the first case of the root, my lord. The Supreme Court now I'll refer to the counsel for my lord. FCA also referred. I will refer to certain paragraphs too. Paragraph 7.
To the Supreme Court judgment.
Supreme Court judgment, Lordship is in the
37 page.
237. Your Lordship will get it.
Yes.
237. Here, my lord, I will refer to paragraph 7 and 8. Paragraph 7, page 240.
Yes.
Talking about Ovijit, their lordship says, this writ petition was allowed by single judge of High Court. It clarified that corporation was only entitled to recover losses that were incurred due to the contractor's dereliction of duties and under the contract as permissible under section 73 of the Indian Contract Act. Learned single judges in this my case, my lord, referred to and discussed, which provides for recovery of damages for the breach of a contract. This should not permit the recovery of losses that were casually distant from the contractor's actions. Further, it held that the corporation had unilaterally determined and imposed demurrage on the contractor and directed it to settle its claims through civil suit of recovery. Corporation filed writ appeal in the division bench and writ appeal was dismissed, the same on the ground of delay. A review petition was also filed, dismissed by the division bench. Present appeals are against these orders. Now the Supreme Court goes on to say, there is another set of, my lord, civil appeals tagged together. Second set of civil appeals are also filed by the corporation. It arises out of SLP number so-and-so. It impugns the decision of the division bench of the High Court of Tripura dated 15/5. Therein, the High Court similarly dismissed writ appeals on the ground that the corporation had no power to recover demurrage from the contractors under the clauses of contract therein. So there were two contentions, therefore two clubbings were done. Having power on part of the corporation and not having power whatsoever by the corporation. Then, my lord, I will take your lordship to paragraph 24 of this judgment. And there also paragraph 9 also in the civil appeals, they talked about alternative remedies. Paragraph, my lord, 24. All right. Yes.
Yeah.
Their lordships, my lord, views and findings start from 246 under the head analysis. After the,
So which para you are referring to?
I am referring to paragraph, my lord, 24.
24, we have scanned the entire contract.
Yes. We have scanned the entire contract in addition to scrutinizing. Here, my learned friend has read it. It is exactly my case that loading and unloading food grains from the railway wagons are immediately the task of the handling contractor. At the destination point only, my lord, I am the handling contractor, not at the receiving point. And
They
here,
are not charges for that.
yes,
They are not handling, they don't find any
Don't.
fault in your handling of the front door, only in respect of this
Yes.
non-availability of trucks.
yes, non-available, and which we raised, which we replied to. Every notice we have replied to annex. Various, even the notices he referred to, my lord, we replied back immediately, next day, mail reply, immediately. Said no question. It may be called disputed or non-undisputed questions, in fact. But the fact remains that in spite of the having the character of some disputes or severe dispute, the Supreme Court kept those things aside and dealt with Section 72 of the Contract Act. And whether unilaterally and without following any procedure, you can exercise if such power, even if such power exists. You cannot. There basically my case. Paragraph 26, my lord, it is important, 253 page. Irrespective of the disputed facts. In 90% petitions, my lord, facts are disputed. That's why there is a counter affidavit and reply affidavit. The real question is whether the contractors had any obligation towards loading and unloading of food grains from railway wagons. In my case, my lord, by way of an affidavit, they admitted that some ONUP is the handling contractor and not high speed at the receiving ends, where wagons come. Same as mine. Task of loading and unloading food grains, railway wagons are not a part of it. Thus, based on interpretation of the expressions charges, now it is important. In the context, we are of the opinion that it did not include liability on account of demurrages. Consequently, the corporation cannot impose and collect demurrages from the contractors. Now, after this paragraph 26, and after these findings by the, actually the ratio is decided by the, in the facts of the case. Now their lordships in the Supreme Court go further in evolving law relating to my lord contract, which is no bar in a given case. Apart from this, then it says, I will take your lordship to paragraph 32. Paragraph 32.
Yeah.
Page 258. It is evident from the above that handling transport contract from 2018 similarly involved loading and unloading food grains from railway wagons within the scope of the contractor's duties, thereby necessitating the inclusion of demurrage as a penalty for non-performance of contractual duties. Thus, the present road transport contract is distinct from the handling transport contract from 2018, as the responsibility of loading and unloading food grains from the railway wagons is absent in the present contract. For this reason, corporation in the present contract has chosen not to include the power to recover demurrages, as such expression charges cannot be interpreted to include demurrages. In the light of foregoing conclusions, we are not inclined to adopt a factual approach for the interpretation of the contractual term charges, and hence the decision of this court in Rachan are of no aid. This was relied on by FCI, as they simply describe demurrage as a charge. Demurrage is undoubtedly a charge. However, such a textual understanding would not help us decipher the true and correct intention of the parties to the present. For these reasons, civil appeals arising out of SLP so and so filed by corporation dismissed, decision of High Court, writ appeal of the High Court, review petition, upheld, decision of High Court of Tripura in writ appeal also upheld. We may clarify that our decision has no bearing on any other remedy available to the corporation, like the institution of a suit for recovery if law enables them to do. Then the other writ appeals also are allowed for the same reasons indicated above. These were by the contractors. So, my lord, the learned single judge absolutely relied on, in my case, the factum of the case, irrespective of the question whether one is exclusively a transport contractor or in part of the contract he is there, excluding the handling parts at the receiving end. Here, my lord, I will take your lordship to only 3 paragraphs of the learned single judge's judgment impugned by them. And paragraph 12 and 16 of the learned single judge's judgment, my lord, and then your lordships, I will invite your lordships to decide as a writ appellate court whether this judgment is interferable or not. He has dealt with, he has taken care of it. He was cautious about, my lord, the ratios of the Supreme Court case and the facts of the case. Paragraph 20, page 267, the judgment starts. I will read from paragraph, my lord, 8 to 12. (266). Right. After discussing everything, his lordship says, from the above, it would be apparent that the allegation of negligence on part of the petitioner company in its failure to place the trucks within the free time is a heavily disputed question of fact. Be that as it may, in the Ovijit's case also it was disputed. Supreme Court said there are disputes, but the Supreme Court took it up.
But sir, you please read that.
Be that as it may, the other relevant question that would also arise for consideration of this court in the present proceeding was as to whether, as per the terms, conditions of the contract, is it at all permissible for the FCI authorities to levy demurrage upon the petitioner unilaterally? I emphasize the word unilateral. By referring to the decision of the Supreme Court rendered in Fuss Corporation and Ovijit, Ms. So-and-so, learned senior counsel for the petitioner, argued that the issue raised in the present petition is squarely covered by the aforesaid decision of the Supreme Court, which has affirmed the judgments of the single judge, Tripura, as well as the Division Bench High Court of Judicature at Tripura, rejecting similar claims of the FCI, relying upon the same condition of the contract agreement. Argued that manager account doesn't have the jurisdiction of the authority law to make unilateral deduction of demurrage from the running bills of the petitioner company, particularly since the petitioner was not the handling contractor of the railway siding. Assuming I was even the handling contractor, in that case also, I will go to the
Sir,
extent
you
of
please, go to the judgment and please make your submission.
was not the handling contractor at the railway siding and hence did not have any direct role to play in unloading the wagons. 10. Refuting above contention, learned counsel for FCI authority submitted terms of the conditions present contract are not the same. This is what they argued. Then paragraph 12. The finding. It is apparent from the facts noted above, the core issue involved in this proceeding is pertaining to a question whether the FCI was empowered under the contract agreement to levy demurrage and deduct such amount from the bills. Same issue has arisen for consideration in Ovijit. By judgment that so-and-so had held Tripura that the levy of demurrage FCI was bad and the same was set aside by holding that the contractor could not be held liable for such demurrage if it can be substantiated that for negligence or dereliction of the contractor, the respondents have suffered loss in the course of transportation. But for that purpose, there has to be an inquiry where the petitioner must have his say. The learned single judge held that the quantum of damage is also to be determined by the following the due process. Again, it is only in that event that the petitioner can be asked to make good the loss and not otherwise. Assuming they have the power to deduct, it must be followed. It must have. They must follow a due procedure. deduction made by FCI from bills of the contractor as demurrage was diverse the terms of the contract and hence not sustainable in law. Be it mentioned herein that both the cases contract agreement contained a provision for levy of demurrage whereas upon the contractor if the corporation suffers or incurs any loss due to negligence of the contractor. Then 13, the decision of the learned single judge Tripura division bench rejecting appeal came up for consideration before Honorable Supreme Court. After considering the terms of conditions contract agreement, Honorable Supreme Court inter alia, my lord, held that since the contractor was not entrusted with the task of loading and unloading food grains under the contract agreement, hence the expression charge would not include any liability upon the contractor on account of demurrages. Consequently, it was held that the corporation cannot impose or collect demurrages from the contractor. It is thus apparent that unless the loading and unloading food grains from the railway wagons falls within the scope of the contractor's duty under the contract or demurrage as a penalty for non-performance of contractual duties would ordinarily not be applicable. The matter could, however, be different if breach of contract on part of the contractor is established through any adjudicatory mechanism. There will have to be some adjudication on the mile of the quantum of demurrage, the hours, whether it was 2 hours or 3 hours, whether I am guilty or not, whether partially the transport contractor is guilty and partially only I am guilty. You cannot simply, in a routine manner, you cannot pass on the buck on Meso. Do you have said? Then, my lord, in the present case, 14, the relevant clause of the contract which comes into play is clause 10A, liability of the contractors, etc., losses suffered. Therefore, my lord, reading then 15, not that the learned single judge in my case, my lord, in this case, overlooked the relevant contractual clauses in my case. And hence the appellant FCI's contention that signatures erred is absolutely unfounded. Going further, the learned single judge also said, paragraph 15, it is important, my lord, 270, it is no doubt correct that demurrage is included in 10A of the contract. Yes, it is included. However, since the writ petitioner was not entrusted with the task of so-and-so in view of the decision of obligate, said clause in the contract agreement, in the opinion of this court, cannot be interpreted as a provision in the contract permitting levy of demurrage upon the contractor. It may be case that due to the default of the part of the petitioner to place the tracks at railway siding, there was delay in unloading of the railway wagons on odd occasions. As a result of which, the uploading could not be completed within the free time, thus inviting demurrage being imposed by the railway upon the FCI. All right, my lord, here posing for a while, my lord, the contractor may not be an angel. There may be 2 hours late. But you must allow him to confirm. How, since the petitioner was not responsible, FCI authorities cannot unilaterally deduct, here is the word, amount of demurrage from the bills. In other words, imposition of demurrage by FCI upon transport contract cannot be based on mere ipse dixit of the general manager or any other official of the FCI coming within definition of clause so-and-so of Annexure 1 of the contract. Such a claim against the transport contractor would be maintainable only when there is a proper determination of the claim by following due process under the law, where the contractor is given sufficient opportunity to produce his version along with evidence. Otherwise, the FCI authorities cannot maintain a claim against the contractor for recovery demurrage saved and except by obtaining a decree from the civil court or any other adjudicative order of it. So, by placing these charts by FCI, can they be said to be a speaking order? Do the charts show that?
No, Mr. Counsel, how you have quantified these damages?
My lord, it has already been pointed out, my lord, page 108 and 109.
108, 109, yeah, what you have pointed out?
My
What is
lord,
the
first of-
adjudication?
They are the committee, my lord, of 4 officers.
Where is that? Where is that committee, adjudication of the committee? Where is the on record? How many hours delay was there on a particular day? on the part of the
For,
this
for that, I will have
contractor.
to, for that, I will have to
He
bring
has
the
not
record.
made
Otherwise, it is,
available- He has not, he failed to make the trucks available for how many years on account of that delay was caused? 1 hour, 2 hour, 5 hour, 10
for that,
hours.
I have
There
to
is that
call for the record,
determination.
my lord. Only that, my lord, the how many, it pays 109, my lord. How many metric
109.
ton he has lifted, he has, that is there, my lord.
Sir, where is the determination, sir?
Yes, the,
Whether.
every month,
on
every
which-
month it is quantified, my
which-
lord. Thereafter
on
the
which
bills
date
are
what
cleared,
you
my
have
lord.
pointed out that suppose on 21/12/2011, you have not been able to made available the trucks, 5 number of trucks or 6 number of trucks, or for 1 hour, the truck was delayed, trucks were delayed by 1 hour, 2 hour, 5 hours, and on account of that, these damages are liable to be charges from you. Where is that determination, sir? You have simply these 10.
108 and 109, yes.
This is what your chart is. But what is the basis for this charging this? Where is that?
If your lordship,
Order,
I have got
where
your
is that
lordship
order,
point, my
Mr.
lord. Yeah.
Barbara, where is that order? Where they have levied the demurrages? Which is that notice or
I think
order?
my learned senior friend has pointed out page
Page?
79.
Huh?
Page 79.
79.
It does not instruct that it preceded any inquiry.
Yes. This 79. Sanction is accorded for sanction order. What is this sanction order?
For passing
What
of the
is the-
bills, my lord.
what is
Every
the-
month, after a month, they pay.
How you quantified this 63,730?
My lord, for that I have to bring the record, my lord. Otherwise, the chart shows that how many. I have
And
got your
any
lordship point.
opportunity of hearing to him that you have not provided the trucks for 5 hours, or on so and so date you have failed to provide such so and so number of trucks. Where is that? Where is the notice? He could have disputed, no, sir. These
Certain
not 5 number of trucks or 3 number of trucks were there, or the delay was not of 2 hours, or it was only of 1 hour. He could have disputed.
Well, how it works, before the coming of the rake, we give the indent to the, all the contractors that this much of rake you are allotted with and you have to, you are responsible for unloading those wagon, my
If
lord.
there is any
And if they
fault on the
fail,
part, there is any fault on the part of the this contractor, you can't this levy the damages unilaterally. That's what the learned single judge has said. That you should have adopted a mechanism to assess the damages and then to give him an opportunity that this is of damages are recovered from them, and the learned single judge has also kept it open for you.
yeah, that is there, my lord.
That is there.
No, my
And
lord, only
even
thing is,
though now you can give him a notice that this much charges are recoverable from you, he'll reply to it and then assess the damages. You can't take it unilaterally, certainly you can't do.
I'm getting your lordship point, my lord. If
Simply
lordship may
because
allow
the
me, my lord, I will.
imposed damages, you have passed it on.
After calculating the,
without even
after
a-
quantifying the damages, my lord, this chart has been prepared, my lord. And we are fair enough where he has lifted, where we have lifted metric tons out of the indent, my lord.
You are fair enough, but this transparency, where is the transparency of imposing these damages?
That must be there, my lord.
That must be there. You should have come with it.
No,
sir.
and another thing is that, my lord, at the time of imposition of these damages charges and clearance of bills, my lord,
Not
he has never
imposition of
objected, my lord.
deduction of-
Only he has
deduction,
come before this
imposition,
honorable
there is
court, my lord,
simple-
and he has not denied this chart also, my lord, in their affidavit in reply. We have annexed these things in the affidavit in opposition. He has not denied, my lord, in the affidavit in reply.
That is not. Intent of again, quality unloading, shortfall, estimating down this, that shortfall. Yeah, what is the shortfall? Only but. Let's simple. एक कौन सा वाला है इनसे है कौन सा सही होता वो सीधा पता so 109 you this 109 what is this 109
109, we have given the breakup with the contractor wise, my lord.
so what was
And
the reason this night placement round of clock siding or late supply of trucks by RTCS which was the reason
Because they failed to supply the trucks, my lord.
where is
So-
that sir where is that you have mentioned 3 night placement / round of clock siding / late supply of trucks by RTCS. Which
Night
was
placement,
the
round of
precise
clock
reason for that?
Yes, which of the reason? Night placement, round
This
of
is
the
the
clock.
precise reason.
Your
The
lordship,
contractor, this contractor can only be charged or could only be charged for late supply of trucks, not for night placement or something.
no, not my lord.
Only for.
For the late supply of.
So where is the specification of that? Sir? It was the precise reason for that. There must be some determination for that. All the reasons have been clubbed together.
Your lordship will give some time. I will bring the instructions, my lord.
Please.
And the record also, my lord.
Where is the question of record now? You would have then the issue, you could have produced it. I think so. There is no such record. Otherwise, you would have produced it. That's all. Judgment reserved.
Oblige, my lord.
Thank you. Yes.
For hearing, item 40.
May I please, your lordship? Your lordship, the matter may be passed over for the time being, your lordship. And it's near counsel, Mr. Kane Chaudhary is appearing, your lordship. Yes.
Password for the day. Password for the day.
Much obliged, your lordship.
Item 41.
Present. Adjourn.
Item 44.
Yes, your lordships.
Yeah.
His lordships, this matter as a public interest litigation that has been filed for the rehabilitation of the people affected, people from the Longjab forest area, your lordship, which has been settling there since 1974, your lordship, after being affected by the flood and erosion.
All the persons have already been evicted.
Not your lordship, not evicted.
How these persons can be allowed to sit on the forest land?
Your lordship, after the river erosion and the flood, since 1974, many
Whatever it may
people.
be, whatever it may be, how can you
Yes, your
occupy
lordship.
the forest land? How can you claim that you should be allowed to occupy the forest land?
No, your lordship, my contention is not.
This is what your essence of the writ petition itself.
Your lordship, our contention only to rehabilitate the affected families, your lordship. Even if it is from it's in different place also.
The writ on nature of a matter was like to be issued directing the respondent not to carry out eviction drive in the Longjam forest area.
Yes, your
So
lordship.
how such a parade can be granted?
Your
This
lordship,
court can say, no, even though if this is a forest area, these persons should be allowed to, should not be evicted.
no
Whether
lordship.
these mandamus can be issued.
For the time, they have
This
been
is the main
rehabilitated,
prayer
your
in the
lordship.
petition, prayer number 1.
Yes, your lordship. But
The
along,
nature of magnanimous or anything like nature be not be issued directing the respondent or not to carry out eviction driving in the Longjap forest area, Nagaon without due process of law.
Your lordship.
So what is the due process of law then?
Your lordship, there are certain,
Issuing a notice and ask you
Yes.
to,
yes,
so
your
they have
lord-
not issued any notice?
No, your lordship,
Can't be.
they have not announced, they have announced through the mic loudspeaker that they should leave the place, your lordship. After which only they have approached before this honorable court, your lordship.
You have already filed a representation.
Yes, your lordship.
What happened to that?
It's no action taken, your lordship.
Okay,
It's
get
in
your
an-
representation decided.
it's an annexure to your page. 29. 29, your lordship. Annexure to your lordship.
Can't do, nobody can do.
Impleadment. Pick up by that. Then-
Who is for the state?
I mean, paying for the deputy commissioner.
Yeah.
The deputy commissioner affidavit that land is already notified in 1928 as a reserve forest.
Fine.
Therefore, my lord, the person who are occupying, they are treated as an encroacher. That is why it is very necessary to evict them from the reserve.
What about the rehabilitation?
Rehabilitation part, my lord. Deputy commissioner.
Ultimately, these persons, whatever these persons are there occupying this land since 1974.
As they claim.
Most, you are also admitting.
Yes, sir.
So what about this? If you have allowed them to occupy the forest land for so long, at least there must be some rehabilitation plan for that.
Some police.
Because you can't, thousands of people are, so encroach.
Residing there, yes.
Then
madam.
you have allowed them to encroach upon that land.
Initially, yes.
20
Then-
villages.
Then, my lord, may I pray that sometime ask the government if any decision is taken or about to be taken for rehabilitation.
You have in your counter affidavit, there is no rehabilitation
Because
program
no,
by the
this is
government at this stage.
This affidavit by the deputy commissioner, my lord, he cannot.
Ultimately, the party, this in 2022 have filed it.
Yes, madam. Ultimately, the government is to
And there
take
is a
decision,
policy,
madam.
your lordships, the policy of
Policy
rehabilitation
is there,
also
yeah.
for erosion affected families.
These petitioners, you have mentioned that
Yes.
the petitioners are situated in district Nagaon, Assam. Many families are settled in the said forest area and living there since last 38 years. Basically, those families living there are the victims of flood and river erosion. Which was your original village?
Exactly.
Yes,
Which was your original village?
your lordship,
And you suffered this eviction or
Yes, your lordship,
this
that-
uprooted from this on account of flood or river erosion, which where
Yes,
is
your
that
lordship.
evidence of that?
Your lordship, that has been mentioned in our rejoinder affidavit, and which also been and a circle officer of many of that particular area has been issued certificate to the erosion affected people, your lordship, and that has been mentioned in
That is at page
65 to 72, your lordship. 65, your lordship. In our rejoinder affidavit. These are the few documents, certificate that we are able to collect. We have annexed here, your lordship. The circle
certified
officer.
that she so and so encroachment number Lumdi area under Lumdi Reserve Forest. Nagama is known to me. What is this? Is known to me.
In the affidavit of
Is cultivation as per record of this range without government unauthorized. Forest, who is the person who has given this affidavit?
No lordship, yeah,
Forest range officer.
it's from page 65, which is in the affidavit in reply to the affidavit in opposition filed on behalf of respondent 3, your lordship.
Yes.
Yes, your lordship. Page 66. চক্ৰ বিষয়াৰ কাৰ্যালয়
What is the name of the person? Riyazuddin.
ৰিয়াজুদ্দিন পিতা জয়ছেদ আলী খান জনিয়া মোজা আৰু circle officer, your lordship.
Which circle?
Bhuragaon Revenue Circle, your lordship.
From where we read it?
First one is Lahori Riyajuddin is Lahori Ghat Raja Chakra, your lordship. Lahori Ghat Raja Chakra.
Who are you, madam? Who is the petitioner?
Petitioner is the General Secretary of Para 5, your lordship, in the main petition, your lordship. He is the General Secretary of Podo Othon Gramin Shramik Sanstha, your lordship.
What is this Gramin Shramik Sanstha?
Shramik
Is it a society or what?
yes, your lordship, it's
Where is that?
registered.
What is the this constitution of the society?
Your lordship,
What are the objects of this society?
they basically works for the
Where is that?
your
So
lordship.
if there is
that's not-
society, then they in their constitution they should have mentioned
Yes, sir.
this is for this purpose. Which area you are operating? You came here and the petitioner said the statement is based on personal knowledge as well as information received from the respondent and also from the official government. The petitioner personally visited the forest area and seen the landless person residing there in the forest area Nagaon. Simply you saw those persons and you filed the petition. What is this? What is your and how those persons who are under the threat of eviction are not being able to approach this court?
Your lordship, as per my knowledge, the petitioner also works basically in that particular area.
Where is that? Your
Yes,
knowledge will
Yes, your
come,
lordship,
madam.
that I
You have
don't have right.
your knowledge you make have many other information
Lord.
about the petitioner, but
Yes,
we
your
are
lordship.
concerned about this.
Yes, your lordship.
That is not.
That we will procure, your lordship, we will submit
And how these persons who are affected are not able to approach this court?
Your lordship, basically, it's in a rural setup, your lordship.
So that's why only because rural sector, so no person from rural areas of Assam has ever approached this court.
No, your lordship, that's
Then?
not, but as the petitioner was working on that particular area,
Which particular area?
your lordship.
How many petitions you have filed in that from that particular area?
Separate application or which is also pertaining to London Reserve Forest area, your lordship.
You have filed petitions.
Yes, your
That
lordship.
is pending.
It was disposed of, your lordship.
Okay.
It's mentioned in para 6, your lordship.
Yeah.
The main application.
Now, this public interest rules, Guwahati High Court Public Interest Rule 2011. It says a specific government in para number 3 of the writ petition as to the specifying the class of persons for whose benefit the petition has been filed. Have you mentioned that in para 3 of the petition?
In para 4, your lordship.
Okay.
Para 3 and para 4.
Okay.
Para 4, paragraph 4, your lordship.
Where you have specified that how such persons are incapable of assessing the court themselves. Where you have mentioned that on account of this, they are incapable of approaching the court themselves. Where is that? Who has authorized you to file petition on behalf of those persons who are under threat of eviction?
Being a social worker, your lordship actively has visited the place.
So why you have not mentioned these persons are not able to approach, are incapable to approach this court?
Yes, your lordship. I'm deeply apologize for that, your lordship.
Huh? You are aware of these
Yes, your
rules
lordship. Yes, your
2011?
lordship. Your lordship. Generally, we, in all our petitions, we generally mention about
You
that.
generally mention, even on your affidavit, you have mentioned.
Yes, your
I've
lordship.
gone through the Guwahati High Court Public Interest Litigation Rules 2011 and do hereby affirm that the present public interest litigation is in conformity thereof. So your affidavit is false. You have not mentioned it. Your affidavit is false. There is no whisper about that, how these persons are incapable to access the approach of this court.
No, your lordship. It is
Yeah, that your affidavit is false.
inadvertently, your lordship.
Where is the question of, it is an affidavit, it's
Yes,
not
your-
an inadvertent
Yes, your
mistake.
lordship.
It's an affidavit on oath. And do hereby affirm that the present public interest is in conformity thereof. It seems it's a publicity interest litigation and not
No,
public interest litigation.
No, your lordship. The
Yeah, you are trying to gain publicity. I'm doing so and so work for these people, and even though if those people are not interested, they may have been rehabilitated somewhere else. You are filing these petitions.
No, your lordship.
You are not going to entertain, and you're supposed to impose heavy cost on such persons without there being any authority, simply because 2-3 photocopies copies of a documents that these are the persons, and sir, these are the persons are suffering like anything. Nothing. You withdraw it with liberty to file representation for redressal of whatever grievances.
Yes, your lordship.
Do it. Otherwise, we are going to impose cost. Yes,
Yes, your lordship, we are
after attempting to argue the matter for quite some time, learned concept of the petitioner on instructions has submitted that she does not want to press this petition, however seeks a liberty for the petitioner to move appropriate representation before the appropriate forum for redressal of redressal of the grievances raised in this PL petition, dismissed with liberty as prayed for.
Item 46.
Please, your lordship, lordship.
This is also a PIL,
This is a writ petition.
Lordship, it's a writ
writ
petition.
petition.
Writ petition.
Lordship, Advocate General Assam is appearing in this matter who is suffering from high fever from last night, lordship. So he's
Mr.
unable to
Saikia.
attend. He's Saikia, lord.
My lord, in fact, yesterday, my colleague
Transporting
confirmed
cattle, they are suffering losses
My
every
lord.
day.
from 2022 onwards.
Let me get-
The urgency is there.
Next week,
My lord, next week, Monday or Tuesday, lordship,
in the month of
Tuesday, ma'am,
Tuesday,
Tuesday,
next Tuesday.
next Tuesday, lordship, it's urgency is there.
Council appearing for the respondent submitted that Mr. The Advocate General who is supposed to appear in the matter is indisposed. Therefore, matter may be adjourned. List on next Tuesday.
Deeply honored.
Obliged, lordship.